Welcome to Lesson 21 in this series, covering American government and politics. In this lesson, we consider presidential and congressional checks on the power of the Supreme Court. By the end of the lesson, you should be able to answer the following questions. What checks exist on the Supreme Court, and how effective are these checks? Let's start by exploring the checks of the Supreme Court held by Congress. Firstly, confirmation of court nominees. Like all appointments to the executive and judiciary, presidential nominations to the court require confirmation by the Senate. The last Supreme Court nomination to lose confirmation was Richard Bork in 1987. Such rejections are rare, and nominees tend to fall out of the process before a Senate vote. In 2005, George W. Bush's appointee, Harriet Miers, withdrew from the process because confirmation was unlikely. In 2016, the Republican-held Senate refused to act on Obama's nomination of Merrick Garland. However, the major impediment to the Senate's power of confirmation is that the candidates must be originally proposed by the president. The Senate cannot choose its own candidate. It is also the case that presidents can circumvent the process through recess appointments. For example, President Eisenhower made 3 recess appointments to the Supreme Court in the 1950s. However, no president has done this since. Secondly, impeachment of justices and the impeachment process. Congress may impeach any Supreme Court justice, but only for high crimes and misdemeanors. Impeachment trials in the Senate are presided over by the Chief Justice of the Supreme Court. The Senate can overrule the Chief Justice when he presides over impeachment trials. For example, the Senate overruled the Chief Justice several times during the impeachment of President Johnson in 1868. However, impeachment of a Supreme Court justice has only occurred once. In 1805, Samuel Chase was impeached but acquitted by the Senate. The Senate has not overruled the Chief Justice during a Senate impeachment trial since the 19th century. Thirdly, court packing. Court packing involves increasing the size of the court to change its ideological balance. The court size is only limited to 9 by convention. The president, so long as he has support of the Senate, can technically appoint more than 9 justices. However, court packing has never been attempted, although Franklin Delano Roosevelt threatened it in 1937. Any attempt to pack the court would require both the president and the Senate to support the move. Fourthly, legislating. Congress can enact new laws to get their own way, so long as they do not contravene the Constitution. From 1973 to 2010, Congress passed laws nullifying Supreme Court decisions 244 times. Congress is most likely to do this if public opinion is against the judgment. For example, Congress passed the Civil Rights Act of 1991 to clarify law regarding employment discrimination, following 5 Supreme Court cases that restricted employees' ability to sue for discrimination. Finally, constitutional amendments. Courts' rulings can be voided by a constitutional amendment. For example, in Dred Scott v. Sanford, in 1857, the court ruled that constitutional rights did not apply to African Americans. However, Congress later voided this ruling with the 13th and 14th Amendments to the Constitution. However, there are significant constitutional obstacles to achieving a constitutional amendment. Proposed amendments require a 2/3 majority in Congress before ratification by 3/4 of the states. For example, several constitutional amendments by Congress to prohibit American flag burning have failed. Let's now consider checks on the Supreme Court held by the President. Firstly, nominations to the court. The President nominates all justices to the Supreme Court. In making his choice, he will select candidates who match his own political ideology and interpretation of the Constitution. For example, Trump appointed conservative justices Gorsuch, Kavanaugh, and Coney Barrett. Furthermore, as already discussed, the President theoretically has the power to attempt court packing. This was threatened by Franklin Delano Roosevelt in 1937, but never carried out. However, checking the court through nominations requires there to be a vacancy. Court packing has never been attempted and would be politically sensitive. Secondly, judicial implementation. The Supreme Court relies on other branches of government to respect and implement its judgments. Presidential refusals to implement Supreme Court judgments are very rare. In 1861, President Lincoln suspended habeas corpus despite the Supreme Court declaring it unconstitutional. Finally, executive orders. The President can pass executive orders that achieve his aims regardless of court judgments. However, such executive orders must be constitutional. For example, President Truman desegregated the armed forces in 1948. He was able to do this 6 years before the court ended segregation itself in Brown versus Board of Education in 1954. In summary, both Congress and the President hold powers to check the Supreme Court. The most significant of these is the ability to nominate and confirm any new appointments to the court. Congress and the President can also sidestep the court by enacting new laws through presidential executive orders or by amending the Constitution. Other checks include court packing, ignoring court judgments, and the impeachment of justices. However, these have either rarely or never been attempted.